All right, so now everything is ready. And like I say, I'm going to return to legal issues today. And the immediate spur for doing this is the fact that the Supreme Court heard arguments on Thursday in a case to do in on the one hand with the 14th Amendment to the Constitution and the idea of birthright citizenship, and on the other hand with the question of the judiciary's ability to issue nationwide injunctions to prevent the use of power by the executive that appears to be questionable in terms of legality or constitutionality. And so we'll get into the substance of those issues, but I'm going to offer a particular framing today as well. And so you can see I'm asking the question, why are we still fighting about citizenship rights and belonging in 2025? And in order to set up that question, I've put a couple different images on the board there. I've put the late 19th, early 20th century image of the suffragettes. And I'll start here with the 14th Amendment. And I'm going to spend a fair bit of time on the 14th Amendment today. I think it's perhaps the fulcrum of the rights revolution that swept the United States in the 20th century. And so understanding the content, the significance, the values enshrined in the 14th Amendment are extremely important to understanding what we're fighting about today. And the idea that, frankly, it was a violation of the 14th Amendment to deny women the right to vote obviously did not settle the issue. It took a long time, a lot of activism. It took women campaigning and ultimately a separate constitutional amendment in order to secure women's right to vote. And I'll get into the details of why I think that question should have been settled by the 14th Amendment, but wasn't. And then I have a second image, and obviously this will probably be more familiar, the March on Washington, the March for Jobs, from the middle of the 1960s with, you may be able to see Martin Luther King in the vanguard of the march and then giving the famous speech on the mall in Washington, D.C. And this is the crux of the campaign for civil and voting rights for African Americans, especially concentrating on the Jim Crow South, which up until the Civil and Voting Rights Act and then their enforcement via federal troops and against the reluctance, at first at least, of many of the states on whom the legislation imposed, that this eventually gave rise to a change in the politics of the South, which had been essentially a one party racial tyranny for the better part of a century. And again, I want to point out that had the 14th Amendment actually been enforced in the Jim Crow South, these protests would not have been necessary. Now, I want to go back to a view I encountered when I was an undergraduate and then when I was a graduate student. So this is the 1980s and the early 1990s. And I took a couple constitutional law courses, one as an undergraduate, one at a law school. Though I was not myself a law student, I'm interested in these issues. And there was a view that was, I think, quite popular, fairly widely accepted and well regarded at that time. And it was a kind of metaphor. You're familiar with a ratchet wrench, I assume, right? This is a wrench that turns or torques in one direction, and then you move in the other direction. It doesn't have any leverage. Nothing happens. You just get to reset your position. And the view that I was taught, or at least that was one of the views being considered about the progress of constitutional rights, especially the rights revolution of the middle of the 20th century, is that this was like a ratchet wrench. Having secured this progress, there was now a stable floor of uncontested basic rights that secured the rights of all persons as citizens in the United States, and that this was a general direction in constitutional law in the liberal democratic world. And that in essence, what it meant to say that this was a ratchet wrench, that this was a stable floor, is that these questions have been settled. They were off the political agenda, that the question really was how much further would we progress, not whether we would ever slide backwards again. And my suggestion to you, I suppose it's pretty obvious with the overturning of Roe v. Wade a couple years ago, is that it's no longer possible to believe that the rights revolution of the middle of the 20th century settled these questions. And to the contrary, we're in the middle of a populist backlash that is once again raising the issue of who really belongs to the nation, who really deserves citizenship and other rights. But let me point out very quickly that when Roe v. Wade was overturned, as much as I objected to the reasoning of the court and the idea of reversing or taking away a right that had been granted and that people had built their lives relying on, I had to admit that the right to abortion and the value of privacy on which it is grounded are not in the plain language of the Constitution. To the contrary, they are at best implied by the values contained in the Constitution. And so there was some reason to believe at least the rights specified in the plain language of the Constitution are secure, even if some of the more perhaps creative extension of the values that undergird those rights and then drawing out their implications was going to be in the crosshairs in right of the conservative majority on the Supreme Court. But what we're seeing with the Trump administration now, I think, is an attack not only on the liberal interpretation of the Constitution, a progressive or expansive interpretation of the values that the Constitution contains, we're also seeing an attack on the plain language of the Constitution, an effort to interpret it in implausible ways to make it more restrictive of who belongs, who gets right, who is a citizen, than frankly the plain language supports. And so the case in front of the Supreme Court on Thursday concerns an executive order that was issued on the first day that Trump was in office that denied that birthright citizenship was available to all people born in the United States. And in ways that I'm about to suggest, this appears to fly in the face of the plain language of the 14th Amendment. So let's go into the 14th Amendment. And I just want to say for a moment why I'm doing this. And I'm doing it for, I think, at least two different reasons. One of them is because, well, that's what's at stake in the case that's being argued on Thursday. And by the way, I'll just note very quickly that the case argued on Thursday really has two different dimensions to it. One dimension has to do with the right, 14th Amendment, birthright citizenship, etc. The other has to do with the capacity of district level judges in a relatively constrained jurisdiction to issue injunctions that bind the nation as a whole. So several, I believe it's 3 district level judges issued nationwide injunctions preventing the executive order restricting birthright citizenship to people born of people who have permanent authorization to be in the country. The injunctions issued were not just for the jurisdiction in which the particular judge worked, they were for the nation as a whole. that's a separate, more technical, probably actually the more focal issue that the Supreme Court was considering in its arguments on Thursday. We'll look at that as well. But the reason we're looking at that issue is because the administration has tried to change the meaning of the 14th Amendment. So that's the first reason to look at the 14th Amendment. But the second reason is because the 14th Amendment is so important and I think, frankly, exemplary. And so here I'll just say very quickly that it's not just the fulcrum or the pivot of the rights revolution. And for reasons we're about to get into, it seems to me that the 14th Amendment might be the high watermark of American rights-based constitutionalism. But it's also the case that this is understood not just in the context of American constitutional law, but constitutional law and maybe even political philosophy across the world. You study the 14th Amendment as containing principles that became regulative, not only in the United States, but for many other societies that believe in democracy, the rule of law, the equality and equal dignity of all citizens, and the need to affirm that dignity by protecting their rights. The 14th Amendment has clear expression of ideas that have become regulative ideas, perhaps for much of the democratic world. So let's get into the 14th Amendment, and I've got on the board the plain language of the 14th Amendment, and you'll have to bear with me. I'm going to spend a little bit of time unpacking this language because I think it's so important. So I'm looking only at the first section of the 14th Amendment. It has 3 different sections, but I want to focus our attention on this section. It reads, first, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, the long-term context for the 14th Amendment is the Dred Scott decision of the Supreme Court, which was a complicated decision. It held that African Americans, whether free or enslaved, could not be citizens of the United States or the states in which they resided. And this then also invalidated the Missouri Compromise, the effort to prevent slavery from spreading to the rest of the states, and in particular to the newly incorporated states. And the worry, right, of the drafters, the radical Republicans, I'll come back to them in a moment, of this amendment is that if they did not make it clear in the Constitution that Dred Scott was wrong, that when the Southern states rejoined the Union, they would do things to disenfranchise or not respect the full equal citizenship of their African American residents. And the evidence was obvious that they would do that. One of the great histories of the so-called redemption period into the middle of the 20th century is called slavery by another name, right? The Southern states, once the radical Republicans were out of power and the Supreme Court became more friendly to the restoration of white power in the South, basically started disregarding the 14th Amendment. So let's look now at the language in that context, right? This is designed to say very clearly to the states and to the Supreme Court, this Constitution requires equal citizenship for all persons born or naturalized in the United States. I hope that that is clear. That's the plain language. That's what Trump is attacking with this executive order. The clause that says, and subject to the jurisdiction thereof, right? It leads to certain questions. There are scenarios in which, for instance, an enemy combatant might have a child in the United States, and because they're an enemy combatant, the United States wouldn't have jurisdiction over them. They would just be a prisoner of war, right? But the way in which I read this, and I'm not sure that I'm being accurate, but I want to at least entertain an alternative reading, right? And that reading is that what the clause and subject to the jurisdiction thereof of the United States means is that when someone is subject to the jurisdiction of our laws, right, that we can tell them that they have to, on pain of coercive penalty, obey our laws. They also need to have the right to consent to the laws, the right that comes with full citizenship, right? That those two go hand in hand is, I think, emphasized by the construction of the 14th Amendment. And I think that's why it's such an important principle for democracy. By the way, I think something else that's really important about the 14th Amendment, it doesn't just say that you're a citizen of the United States if you're born here and subject to the jurisdiction of federal laws. It also says that you're a citizen of the state in which you reside. And that this is the beginning, the place where the federal Constitution asserts jurisdiction over the states. Prior to those few little words, and of the state wherein they reside, it was not the case that the states had to uphold the constitutional rights contained in the Bill of Rights or enshrined in the Constitution. That, in fact, the Constitution was understood as only binding on the federal government. So a state could, if it didn't have it in its Constitution, violate the freedom of speech, etc., the freedom of religion, the right to assemble, the freedom of press, as long as it wasn't the federal government doing it. And again, the 14th Amendment says no. The rights of American citizens are rights not only against the federal government, but also against the state. Let's now look at the second sentence, and it has three clauses. So we're going to go through them a little bit painstakingly. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And so not only are you a citizen if you're born in the country and subject to the jurisdiction, you have the rights, and the states cannot take those rights away from you. Citizenship is sacrosanct. Continuing, right? Nor shall any state deprive any person of life, liberty, or property without due process of law. Now, I want to note two things about this clause. The first is a shift in the subject of the clause, right? The previous clause talks about citizens. This clause talks about persons. And I think it's worthwhile noting that persons is a broader class than citizens, right? That this refers to persons in the United States, irrespective of their citizenship status. And so again, part of the attack of the Trump administration on the 14th Amendment is the effort to say, essentially, persons who are not here legally are not entitled to due process of the law. They can be summarily deported, and then they're outside of our jurisdiction, and they have no capacity to assert the rights protected by the Due Process Clause of the 14th Amendment. Finally, nor deny to any person within its jurisdiction the equal protection of the laws, the so-called Equal Protection Clause. And again, please note, persons, not citizens, and the idea that every person is entitled to the same protection of the law that every citizen and the most privileged among us is entitled. This is a radical assertion of political and human equality, right? And so this is what really, I think, we thought we had settled. That it was there in the 14th Amendment did not settle the issue, right? Women still had to fight to get to vote. African Americans still had to fight to overcome the racist tyranny of the southern states under Jim Crow, the reorganization of the Ku Klux Klan, the use of race-based terrorism to prevent African Americans from asserting their right. And by the way, the racism, as we've talked about in the past, of the federal government as a whole, given the really important role of Southern senators and congressmen in getting the New Deal passed. They built into the New Deal all kinds of racial exclusions, right? That the effort to overturn this is an effort to overturn Jim Crow and the racism of the New Deal, is an effort to get equal protection of the law, due process under the law, equal citizenship protected. The fact that it was there in the 14th Amendment did not suffice. Now, having said that, I want to think for a moment about the role of the 14th Amendment in American constitutional history. And here I'm going to start with a metaphor, again, popular in constitutional law. And the metaphor refers to Odysseus or Ulysses, right? And if you remember the episode from the Odyssey where Odysseus says, I want to be the one person who hears the siren's song and survives. And so what he does is he gets his men to tie him to the mast of his ship. And he instructs his men, you have to fill your ears with wax so you don't hear the siren song. And then you have to leave me tied to the mast until we're well past where the sirens are located. And no matter what I ask you to do, you can't untie me. Because Odysseus knows, like every other human being, if he hears the siren song, he will jump overboard and then they will devour him. So this is a metaphor in the way in which it's used in the study of constitutional law for what's sometimes called self-binding. And the idea is that we worry that in the future we may not do what we think our principles and our deepest political or moral commitments require us to do. That we end up very often, due to fear or anger or other destructive political emotions, getting carried away. And that ultimately, hopefully, we come to regret those episodes, but even better is to anticipate those episodes and prevent us from having the power to do things that eventually we will regret as violation of our fundamental commitment to each other. Our core social compact requires that we not take citizenship away from anyone, that we not abridge their citizenship, that we not deny them of due process under the law or equal protection of the law. And the radical Republicans who had fought the Civil War and a bloody, awful war in light of what the Supreme Court had done in Dred Scott, and in light of the fact that the southern states attacked the North rather than allowing a president who was going to restrict the spread of slavery to take office and have jurisdiction over them, indicated that this is likely to reoccur as a problem. And so we need to put it into the Constitution to protect ourselves from ourselves, to protect our regulative principles, our highest order interests, from the temporary temptations of the political moment. I want to be as clear as possible. The Trump administration recognizes that the 14th Amendment prevents it from doing a lot of what it wants to do, and it's therefore targeting it because it does not want to be restrained. It wants to give in to the impulses and, in fact, to make them regulative impulses. I don't know if you saw this, but last week, I believe he was in Qatar. At the time that he said this, Donald Trump said that the 14th Amendment is stupid, right? And I believe what he meant in saying that is that birthright citizenship is stupid. And I believe he has in mind a scenario in which, for instance, somebody comes to the United States on a short-term tourist visa, gets maybe 2 or 3 months to be here, and they're engaged in what is sometimes called citizenship tourism. They're 8 months pregnant, right? And so they come here in order to have their child so that their child has American citizenship. And if that's not our intention, then maybe there is something stupid about having immigration law that does not prevent people who are 8 months pregnant from getting a short-term tourist visa to come to the United States, right? But the idea that it's the 14th Amendment that's stupid, as opposed to the loophole in the immigration law that's stupid, that the right way to fix this problem is to reform immigration law, not to attack the Constitution and its extraordinarily important language in the 14th Amendment. I think it's incredibly revealing about the Trump administration that, in a sense, the crux of the conflict between Trump and the judiciary really focuses on the plain language of the 14th Amendment. So let me now turn to the second issue very quickly. And this is the question that really is the main question in front of the court on Thursday. And I think part of what troubles the justices is that the Trump administration is focusing on the narrow jurisdictional issues. Can judges in a single jurisdiction issue nationwide injunctions, right? And this is typically the case where their rulings have apparent national implications. So to take the case at hand, a federal judge in Vermont says it is obviously adverse to the plain language of the 14th Amendment to deny somebody citizenship who's born in the United States just because their parents are not authorized to be in the United States. And by the way, there's nothing about being in Vermont that determines the outcome of the case. What determines the outcome of the case is the plain language of the 14th Amendment. And so in making that decision, the judge says, I'm making a decision that doesn't just apply to the details of this specific case in this specific jurisdiction, but should apply to everybody in the United States, and therefore I'm issuing a national injunction. And I want to point out that this has been done a lot recently, and it's been done, well, often in ways that introduce certain problems, right? Some of the problems have to do with essentially what's called venue shopping, right? And so take a clear-cut case, the Fifth District Court, headquartered in Texas, including Louisiana, et cetera, is a very conservative court, right? And is often actually at odds with a very conservative Supreme Court, right? It's moving faster and doing more radically conservative things than even the Supreme Court can countenance. And on the other hand, the Ninth Circuit, headquartered in California, is a very liberal jurisdiction or court, right? And some of this has to do with the fact that the senators from the states in the jurisdiction that the court controls get vetoes over those judges, and so only conservatives get to practice in the fifth, only relatively moderate or liberal judges in the ninth. And so you end up saying, well, which district is most likely to rule against Donald Trump? Let's go to the Ninth Circuit in order to get the decision we want. Which, right, circuit court is likely to uphold a decision against Joe Biden? Let's bring our suit in Texas so that we get the Fifth Circuit reviewing it, and it's likely to be upheld. And this kind of venue shopping, and effort to use the right ideological leaning of one of the two right districts to invalidate legislation seems problematic, right? We should not be relying on just one circuit or one judge to make policy for the country as a whole or interpret the laws for the country as a whole. And then you add to that, it's not that unusual at this point to have one judge saying one thing in one circuit or district and another judge saying a different thing in a different jurisdiction, right? And so it potentially introduces some incoherence into the law. And so the idea that there's a real problem here and that it needs remedy, I think is important. But the idea that the right remedy is to force the judges to only rule in the particular case with regards to the particular plaintiffs or parties in front of them, and to limit their decision to them and to their jurisdiction, as Judge Ketanji Brown Jackson pointed out, this administration has been playing a game of catch me if you can, right? Or a shell game, especially with the deportations, getting the people it wants to deport very quickly out of the Northeast or the West and into the South in order to put them in areas that are less likely to enjoin or issue an injunction preventing them from deporting them. And then note, right, that the real shell game here is moving people and then deporting them so quickly that they don't have recourse to due process, that they can't reach out to their lawyers, or their lawyers can't find them. The lawyers don't know which judge to file their motion with, because right, they don't know where the defendant they represent is physically, whose jurisdiction they're in. And so, having right said that this can be abused, there may be good circumstances in which this is the case. And more generally speaking, if right you have something like an effort to use an executive order to violate the 14th Amendment, and you restrict the jurisdiction of the judge, right? You can only hold, in this case, with these plaintiffs in this jurisdiction, then the courts are going to have to wait for new suits to be brought with new parties in new jurisdictions. And it's entirely possible that the administration won't appeal the particular case, right? So that the underlying principle, does the 14th Amendment protect birthright citizenship for everyone or only for a subset of the people born in the United States, is never adjudicated on a national basis by the Supreme Court. And so the idea that, right, the gravity of the 14th Amendment and of the significance of birthright citizenship to our understanding of the rights and the legal standing of persons in the United States is offsetting the need to figure out what to do about nationwide injunctions, I think is really important in this case. And we'll have to see what happens. I suspect it looked, I don't know if you listened to the arguments or not. I love doing that. I do have to say it's one of the few remaining elevated aspects of American politics. Too often, congressional hearings degenerate into posturing or shouting matches or people talking past each other. But the Supreme Court remains a genuinely collegial, deliberative, and a place where there's still a discussion focused on value and principle and law. It's I find it to be edifying to listen to the Supreme Court, and so it does appear, excuse me, that based on what I could see, and you've heard me say before, if you want to know what the court's going to do, try to count to five, right? That there were five or six of the justices who appeared to be attracted to the idea of articulating a principle that says this is when judges can issue nationwide injunctions under these circumstances and not in general. So with that in mind, let me now pivot to the broader question of, right, on the one hand, what's happening between the Trump administration and the courts, and second of all, what it feels like to be in a constitutional crisis. And I'll start with that second point, right? And my claim to you, we've been talking about this for months now, right, is that we need to be careful in using the language of constitutional crisis, that we shouldn't use it permissively or promiscuously, because that will then water it down and not let us call attention to something that is a genuine constitutional crisis. But in a situation now where a district level court, a circuit level court, and the Supreme Court have all said the same thing. For instance, that Abrego Garcia needs to be returned to the United States, or that the deportations need to stop. And please note, right, there was a decision yesterday indicating that the Enemy Aliens Act cannot be used any longer to deport Venezuelans, right? And it's an injunction, it's an emergency injunction from the Supreme Court until the case is decided at each and every level. But it appears that the right administration is doing everything that it can to evade, to dissemble, and ultimately to disobey the direct instructions of courts all the way up to the Supreme Court. And so, in that sense, I do think we are formally and precisely in a constitutional crisis in 2025, because we have two branches of the federal government that have completely opposite and irreconcilable interpretations of what the law and the Constitution permits. And rather than working out their impasse or disagreement, or as I think should be the case, the president ceding to the courts the right to interpret the law and the Constitution where it traditionally resides, we have the administration using fig leaf pretext to disobey what the courts are telling them to do. And so we have a executive who is unrestrained by the law, or to put it differently, only follows the law in the way that it interprets it, right? Which is equivalent to being unrestrained if they don't interpret it with fidelity, if they don't actually construct the meaning of the law in a way that plausibly affirms what the law actually means, or is at least a plausible interpretation. And so I'll say this very quickly. I think that fear is spreading to more and more institutional contexts in the United States. It's spreading to colleges and universities. It's spreading to the people who work in colleges and universities, to students and faculty and staff and administrators. It's spreading in the press. It's spreading in law firms, right? And it's essential to be able to gain legal counsel in order to be able to assert and uphold your rights. It's spreading to all kinds of civil society institutions, including institutions that work on behalf of the Democratic Party. And so the idea that we are witnessing a constitutional crisis, even if many of us are unaffected in our day-to-day lives, I think is extremely important to notice. And again, part of the backdrop to Thursday's Supreme Court deliberations. So with that in mind, let me review some of the details, right? The Supreme Court has demanded that the Trump administration facilitate the return to the country of Abrego Garcia. It has enjoined the use of the Enemy Aliens Act to deport Venezuelans, and it appears skeptical of restrictions on birthright citizenship or of an interpretation of the power of judges to issue injunctions that would effectively allow the administration to continue to violate the 14th Amendment. And this has bearing then for the hearing occurring in Maryland in the court of Judge Paula Zenas, who has ordered the Trump administration, following the Supreme Court's ruling, to take steps to immediately facilitate the return of Abrego Garcia. If you're following the details, you know the Trump administration initially refused to comply and then said, well, give us a week. We think we are actually close to being able to get his return. And then nothing happened in that week. They asked for a second week, and the judge said no. I think that they have tested the judge's patience, and in fact, this is just a delaying tactic, just more obfuscation, and it's clear from the reports in the press and actually from what Donald Trump himself said. He could pick up the phone, speak with the president of El Salvador, and Abrego Garcia would be on a plane back to the United States. The administration does not want to return him, does not want to facilitate his return, does not want to comply with what the district judge, the circuit court, and the Supreme Court have told them they have to do, right? And by the way, most recently, the attorney for the Department of Justice has denied that Abrego Garcia was wrongly deported. Again, clearly testing the patience of Paula Zenas, the judge in the case. I'll move on to Harvey Wilkinson's opinion, which we looked at together in detail a couple weeks ago. His claim that the Supreme Court's decision does not allow the government to do essentially nothing, and that if the government does essentially nothing, this is the two branches just having a head-on collision with each other. In other words, a constitutional crisis. Now, I'm going to add one more thing to this because I think it really helps to illuminate what the true subtext, the motive, the impulse behind these cases is. So please note, right, that the Trump administration has removed temporary protective status from Afghanis who assisted the U.S. military during our war against the Taliban and our effort to assist Afghanistan in reorganizing its state along more democratic lines, right? So these are people who, right, worked with our military and who credibly claim that if they're returned to Afghanistan, where the Taliban is now back in power, they will be in harm's way. They may be jailed, they may be tortured, they may be killed. And the Trump administration says, we don't care, right? Send them back. Please note, right, the same thing is true with Venezuelan dissidents who have protested against the Maduro government, a socialist, populist, authoritarian government that the U.S. clearly doesn't like, and we've supported their right to dissent. And then, again, we recognize if they're returned to the country, well, they're going to be in harm's way. But the Trump administration is saying, too bad, we don't care, right? At the same time that we're doing that, the Trump administration just this week offered refugee status to white Afrikaners from South Africa. Right, and I'll just say this very briefly. I don't know enough about their situation, so I'm not positive this is correct. But what I have looked at indicates that Afrikaners are roughly 7% of the South African population and control roughly 70% of the wealth in South Africa. And that South Africa as a society is failing as a state to control crime. It's rampant, right? And that black South Africans, white South Africans, Afrikaners are subject to crime, violent crime, on a far too regular basis. But why signal out white South African Afrikaners for particular protection when you're denying it to the Afghanis, when you're denying it to the Venezuelans? And I'm going to suggest a simple idea that this is a reassertion of the old nativist pre-14th Amendment understanding of who deserves the privileges of American citizenship, where American citizenship is a marker of white racial privilege, right? It's the white Afrikaners and not the brown or black Afghanis or Venezuelans who belong in the United States. That this seems to be clearly what is guiding the discrimination here. You can have protected status, you can't. You can be a refugee, you have to get on a plane. So let me say one more thing about this, and I want to put this in a still broader context. And in so doing, I'm going to draw on a couple of books that I've spoken with you about, one of them quite recently, Taking Back Control by Wolfgang Streeck, which is about how democracies have lost control over their economies in an era of hyperglobalization, and how many citizens feel that they are now unprotected by their own nation states because their nation states have lost the capacity to provide the services that citizens need to survive in the 21st century, to be secure in their economic and social standing in their society. The other book is by Christina Beltran, an interesting political theorist at NYU. It's called Cruelty as Citizenship: How Migrant Suffering Sustains White Democracy, right? And we talked about that book quite a while ago, I think maybe even in the context of the 2020 elections. But having said that, I think their frameworks together help us to understand a little bit better why Trump is pursuing an agenda that is at loggerheads with the clear language of the 14th Amendment of the Constitution. And so I'm going to start with Streeck and with the idea that if we really want to better control our economy, better protect our citizens in the 21st century, we may have to unwind some of the global integration that has developed in the economy over the last 40 or 50 years. And by the way, it's really difficult to do that. In a sense, I think, right, the ham-handed effort to do it with the tariffs shows how hard it is to do. And then the fact that the tariffs prompted a crisis, right, indicates be careful, right? If you do this in the wrong way, you will do grave damage to the economy. You won't, in fact, improve people's lives and economic standing, which is the whole point of this. So you need to do deglobalization intelligently, carefully, with strategy and patience and allies. It involves industrial planning, figuring out how to make more of what you consume, either at home or in coordination with countries that you're allied with and that you're confident won't use the fact that you're dependent upon them economically to undermine your efforts to control your own economy. So you need to cultivate allies to create limited trade relations. And for us, the United States, this would mean surrendering some, at least, of our exorbitant privilege, our ability to borrow money cheaper than most of the rest of the world can to run a deficit as high as we can. I haven't spoken with you at all about what's happening with the budget, but please note, right, we've got a budget that is caught up in committee right now, maybe have to be renegotiated. We'll have to see what happens, but that is likely to add trillions of dollars of debt to our already nearly $37 trillion federal debt. This is very risky for the United States to try to do this. It's also the case that if we're going to do this, if we're going to deglobalize, it will be costly. And it therefore requires building consent, not simply asserting power. One of the ways Wolfgang Streeck expresses this is we would have to make more and buy less, right? My phone costs around $800, right? And I'll be honest, that's an iPhone that I purchased used, right? It's not a new phone. If the same phone and new, it would be about $900. So I didn't get a great savings. But if it were made in the United States, the estimate is that it would cost between $3,000 and $3,500, right? So if we're really going to um, reshore or nearshore, right? Not rely as much on China or India because that involves losing too much control over our capacity to, right, manage our own economy. Well, then we're going to have to be willing to pay more, and that probably means we will buy less. And to get people to uh, actually consent to changing our, right, access to cheap consumer goods in order to increase our political and democratic power over our economy involves making an argument to the people. And frankly, the Trump administration has not made this argument to the American people. They seem to want us to believe that we can have our cake and eat it too. Their idea of a Mar-a-Lago Accord, which is loosely based on the 1985 Plaza Accord that devalued the dollar against the yen and the mark and other currencies, it is a kind of fantasy. I think there's really no other way to describe it, that the United States will somehow be able to maintain its exorbitant privilege while devaluing the dollar and reindustrializing. It just is not that easy. We're not that powerful. So if we're going to do this, it's going to be hard and it's going to require patience and, frankly, competence and capacity that this administration seems to lack. So they fasten onto the fantasy that we can use tariffs to regain control of our economy. And then, by the way, let's also make America white again. And that's where Christine Beltran's work comes in, and the idea that we can essentially find symbolic enemies, the people who we want to blame for our lack of control over our own economy, and that the rest of the world, especially the Chinese, that we need to hit them with tariffs to punish them for their erosion of our ability to control our economy, that the immigrants who are here without authorization are interfering with the cohesion of our society and our ability to control and care for and affirm the economic security and standing of all of our citizens. It's their fault, right? And then to restrict immigration and citizenship, right? is a further way of saying if we, the real Americans, the natives of our country, were able to control our politics, none of this bad stuff would be happening to us. And I'm going to conclude by saying I think this stuff is bound to fail, right? It's bound to fail in addressing the true motivating impulse, the desire to have greater control over our economy so as to have greater economic and social security, to have a sense that this economy works for all of us and not just the hyper wealthy, that prosperity is still possible. So what happens when the policies pursued by the administration on the promise that they will make America fair again, make prosperity available again, fail because they're purely symbolic as opposed to real action? Well, two possibilities. I think one of them is that we learn our lesson, right? We've got to do things the hard way. If we're going to succeed, we need to elect politicians who aren't mere populists, but who actually have the talent and the dedication and the honesty to tell us what we need to do and to guide us through the difficult shores of the difficult straits of renegotiating our relationship to the global economy. That would be, if you will, the good outcome. We learn our lesson and we do better the next time. The other possible outcome, it seems to me, is frankly that, well, if the only tools we have are tariffs, deportations, restrictions on immigration and citizenship, and they haven't worked, we have to do more of the same. We have to do it more aggressively. We have to do it more cruelly. We have to do it with fewer legal or constitutional constraints. And so my worry is, frankly, that the failure of these policies to deliver what they promise may prompt the Trump administration and those who support it to become more aggressive, to double down on action that is both destructive and clearly illegal and unconstitutional. I will stop on that somber note. I want to hear your thoughts and your questions. I'm happy to come out of the slide and to see that everybody is here now. That's great. We started out with 20 and we're up to the full complement at the end of the class. Who wants to start us out with a thought or a question? Go ahead, please. You're still muted.
It's Sandy.
Yeah, hi, Sandy. I know you're not Michael. Go ahead.
Not Michael. What happens? I know we're talking about getting Garcia out. What about the other people in El Salvador who were denied due process? Is anybody speaking for them?
Yeah, so I do believe the ACLU is litigating on their behalf. I think, in a sense, Fillmore Abrego Garcia has become the face, right, to all of this, and his case is complicated, and there is a sense in which he was in fact subject to a deportation order, right? He just couldn't be sent to El Salvador. That's the one place they couldn't send him, right? And so, having said that, I think we're really focused on him, and I think it's not a bad thing that we're focused on him because he humanizes the story, right? He does have an American child. He does have an American wife. He does not have any criminal convictions. He's not a gang member. He doesn't fit the profile that the Trump administration claims he fits. And if he had been, right, given his due process rights, all of that would have been discovered and he would not have been deported, right? So having said that, I believe the ACLU and others are trying to bring similar suits on behalf of the other people who were deported. And I don't know enough to know if that's case by case or if that's class action. And frankly, I think part of the problem here is that the administration is taking a wash their hands of it approach, right? They're no longer in our jurisdiction, so there's not much that can be done. And that, in a sense, what we'll have to see. So, right, Judge Boasberg, who is the judge who said, turn the planes around, I believe is exploring contempt of court findings or a trial to determine whether or not there's been contempt of court against the Trump administration, right? And then the question would be, what would be the consequences of finding that the administration directly and knowingly violated a judicial order not to deport those people, right? And I think you could see a scenario in which either criminal or civil contempt against people other than the president. The president is essentially immune, thanks to the Supreme Court, from any kind of adverse consequences from having violated the law. But the people who are in, right, the Department of Justice, the Department of Homeland Security, the Immigration Customs Enforcement Agency, the military, right, who disregarded the judge's orders and who are found in contempt of court, they may not be immune. And they may not be prosecuted or sentenced or fined as long as Donald Trump is president, but Donald Trump is not going to be president forever, right? And some of them are lawyers. Some of them could actually lose their license to practice law. And so at some point, it may be that the incentive to return these people grows, right? Because there's starting to be genuine consequences for the people in the administration who did this. And then we'll just have to decide. Donald Trump has a long history of letting the people who've done his dirty work and then face the consequences hang, right? They're out to dry. It doesn't matter to me. I skate away. Or does he, in fact, return them? I would note, right? Donald Trump is not a very popular president right now, but he's more popular in 2025 than he was at this point in 2017. And the issue on which he is most popular is deportation, right? And so until he starts paying a price for this politically, I'm not sure what restraint we will have. Now, let me mention one more issue here. And again, this is not my area of expertise, and I've not done a lot of research. I'll just repeat to you what I know. And that is that it appears the federal government is paying the government of El Salvador to detain or imprison the people we've deported, right? If that is the case, there may be an argument to be made that we do, in fact, have some jurisdiction, right? And that would be really important. But that's going to take, I think, quite a while, and it will be controversial. It's a complicated question. Does the fact that we paid El Salvador actually give us jurisdiction over the people it's holding for us? I wish I had more information, Sandy. That's the best I've got.
Well, thank you.
You bet. David, you got your hand up? Go ahead.
Yeah, let me make sure I'm unmuted here.
You're fine.
Yeah.
Yep.
Okay. The case, the Afrikaans exception that's recently come down, I think reveals the true colors of the Trump administration. And it's a throwback, isn't it, to the late 18th and early 19th century quota system we had about which immigrants from which countries could come to the United States or which had priority. And
Late 19th and early
it just
20th.
seems to me to reveal the true colors of this administration. The second thing I wanted to say is that it's really interesting. I've been an ACLU member since the 1960s, and for the first time that I can remember in a couple of decades, the focus has returned to the fundamental rights that are in the Bill of Rights. I mean, they've wandered off in other directions, like schools and whether there's equity in school programs and things like that. But it's really interesting to see this return to their fundamental origins.
Yeah, and so I completely agree with you about the idea that although thanks to legislation passed in the middle of the 1960s, racial quotas are no longer in fact legal, right? And
Right.
they were implemented in the late 19th century with Asian exclusion and then solidified in the early 20th century in the aftermath of the civil rights law and the height of the Cold War, when we were trying to shed our image as a racial or racist imperial power, we removed at least some of those quotas, right? Not as
Not all.
completely as maybe we'd like to think we should have. But yes, there's a return to, and I want to suggest it's not just immigration law. Really, it is a sense of who belongs in this country, who has full citizenship rights. And that's exactly what the 14th Amendment is designed to address. Please note that the Trump administration position in court is that the 14th Amendment is only meant to protect emancipated slaves, right? And this flies in the face of the plain language of the 14th Amendment, which says all persons, right? It doesn't say formerly enslaved persons, it says all persons. The radical Republicans, right, the Republicans of Lincoln's time who were anti-slavery, both because slavery was an abomination, but also because slave power, so-called, meant that we were on our way to becoming an oligarchy or an aristocracy, right? That they said, let's not only protect the formerly enslaved, let's protect all persons from disenfranchisement or the implementation of unequal status under the law, right? And so yes, the Trump administration is trying to return to the era of Dred Scott, not necessarily to enforce slavery again, but to enforce a racially hierarchic conception of citizenship. And that I think it's hard to interpret what they're doing in any other way. David, what was your second comment? Refresh. Oh,
Oh,
ACLU. I got it. Right. And so I'll just point out very quickly, in a sense, the reason the ACLU, I think, pivoted away from those core right issues is that ratchet version
yeah,
of
exactly.
right constitutional progress. Once the constitutional progress is secured, the floor is set. Now we can work on building up. We don't have to worry about the foundation so much anymore. And lo and behold, here we are in 2025, and the foundation appears to be unstable again. And so we have to go back to
Yeah.
relitigating those fights that we thought were over and taken care of. Anybody else with a thought or a question today? David, good comments. Thank you. Thank you as always for those. All right. So I'm on my way to get on a plane. I suppose I better go pack my bags. Great being with you guys. I'll join you from Rome next week. Looking forward to it. Take care, everyone, and
Safe travels.
see you in a week. Thank you. Take care, everybody. Bye bye.